welcome to Crime Before Modern Law. Here, we explore how crime and justice functioned before modern policing. If you find this topic interesting, feel free to leave a comment telling us where you are watching from. And, if you would like to support the channel, a like or subscription always helps. Before modern police departments, before full-time prosecutors, and before judges were trained in professional law schools, courts still existed. People still needed a place to settle fights, punish wrongdoing, and decide who owned land or owed money. But the question, who served as judges, had different answers in different times and places. In many societies, the judge was not a separate job at all. Judicial authority often came from status, being a ruler, a priest, a local official, a landowner, an elder, or a respected member of the community. In some systems, one person led the court, but did not decide alone. In others, the judge mostly managed a process where the community gave the final decision. This documentary-style explanation looks across major historical periods and regions to show who held judicial power, how they were chosen, and what that meant for crime and punishment. First, it helps to define what judge means in older systems. A judge can be, 1. The person who presides over a court session. The person who declares what the law is, the person who decides facts, who did what, the person who chooses the punishment. In many older courts, these roles were split. A leader might preside, but the community might say the law, or a professional legal official might run the hearing, while lay people decided guilt. So when we ask who served as judges, we must also ask, which part of judging? A second key point is that older justice systems often had overlapping courts. A village might have one kind of court, a lord another, a church another, and the king another. A person could be judged by different authorities depending on the type of dispute and the person's status. With that in mind, we can move through several major patterns. Pattern 1. The ruler as judge. In many early states, the highest judge was the ruler. This could mean a king, a pharaoh, an emperor, or a city ruler. The idea was simple. Law was part of rulership. If the ruler was responsible for peace and order, then the ruler also had the authority to decide disputes and punish crimes. Even when rulers did not personally hear most cases, they often remained the source of judicial power. Others judged in the ruler's name. In medieval Europe, for example, the king was seen as the fountain of justice. Over time, royal courts became more formal, but they still acted as the king's courts. In many places, the ruler's authority was also linked to religion, which made the ruler's role as judge feel like part of a sacred duty. Rulers could also act as a court of appeal. If local courts failed, or if a conflict involved powerful people, the ruler's council or palace court might hear it. This pattern had strengths and weaknesses. A strength was that it could unify law across a wide territory. If the ruler's court set rules, local courts might copy them. A weakness was that justice could become personal and political. The closer a case was to power, the more it could depend on favoritism or pressure. As societies grew, rulers delegated judging to officials. Pattern 2. Local officials as judges. A very common historical solution was to use local administrators as judges. In many places, the same person collected taxes, managed records, kept order, and also handled court cases. Imperial China is a clear example. The county magistrate was the main face of government for ordinary people. He could act as investigator, prosecutor, and judge, all within a single office. The magistrate was usually appointed by the state, often from men who had passed competitive examinations or held recognized credentials. He relied on a staff of clerks and rummers. This meant the judge was deeply tied to state administration, not separate from it. This setup had practical benefits. The government did not need a large separate judiciary. One trained official could keep the system running, but it also raised problems that modern systems try to avoid. When the same official investigates, accuses, and judges, the process can become unbalanced. The magistrate's main goal might be social order and meeting quotas, not protecting individual rights. Similar combinations happened elsewhere. In many empires, provincial governors or city officials had judicial authority. Even in some European settings, local administrators presided over courts because they represented the crown or the lord. Pattern 3. Elders and community. Leaders in small-scale societies and many village-based communities, elders often served as judges. This did not always mean a single elder deciding everything. Sometimes elders formed a council. Sometimes they mediated, aiming for settlement rather than strict punishment. Elder courts often focused on restoring peace inside the community. That could mean compensation, apologies, or agreements about future behavior. In these settings, the judge was often more like a respected mediator. This approach fit societies where people lived close together and had to continue dealing with each other after the case ended. However, elder-led justice could also reflect local power. Elders might favor their own families or groups. People outside the community, or lower status members, could be treated as less credible. Pattern 4. Religious judges. In many civilizations, religious institutions held separate courts and judges. In medieval Western Europe, church courts handled many issues tied to marriage, morality, and clerical behavior. Church officials judged according to canon law. This mattered because large parts of life were considered religious matters. In Islamic societies, the Qadi served as a judge applying Islamic law, usually appointed by political authorities. Over time, some states developed senior judicial offices, such as a chief judge who supervised appointments. The Qadi was not simply a local elder. He was expected to have learning in religious law and to decide disputes using recognized legal methods. Religious courts often had their own procedures, records, and ideas of proof. This split created a world where one person might face different judges depending on the issue. A marriage dispute could go to a religious court, while a property dispute might go to a state court, and a violent crime might fall under yet another authority. Religious judges could provide stability because they used a shared body of law that did not change quickly. But religious courts could also create conflicts with rulers, and they sometimes treated people differently depending on religion, gender, or social standing, depending on the time and place. Pattern 5. Lords and feudal courts. In many medieval systems, especially in Europe, landholding power created judicial power. A lord could hold a court for the people living on his land. These courts often handled local disputes, minor crimes, and issues about duties owed to the lord. In England, for example, local justice involved multiple layers. There were shire courts and hundred courts, and also manorial courts tied to local lords. In earlier English practice, major local courts could be presided over by leading officials and sometimes a bishop, but decisions were often made by local men attending the court who declared the law. In other words, the presider was not always a judge in the modern sense. The community's role was central. Over time, royal justice expanded. Kings sent traveling judges, often called itinerant justices or justices in air, to hear serious cases and enforce royal authority across counties. These judges were royal officials, sometimes drawn from experienced administrators and legal specialists. Later, England developed local magistrates known as justices of the peace. These were not modern police. They were local men, usually from the gentry, trusted to keep order and handle certain legal tasks in their counties. This feudal and local magistrate pattern shaped much of pre-modern criminal justice. It meant that judge could be a neighbor with status, not a trained professional. It also meant that law could vary by place, because lords and local communities had different customs. Pattern 6. Lay judges and citizen juries. Some societies placed judging in the hands of ordinary citizens, at least for certain cases. Ancient Athens is famous for large citizen juries. Many cases were decided by panels of citizens selected for service. Officials such as archons had roles connected to the courts, but the deciding power in many trials lay with citizen judges. This was not modern jury trial exactly. The system was part of a direct democracy culture. The idea was that citizens should judge citizens. A benefit of this approach was that it limited the power of single officials. It could also reflect community values, but it also made decisions sensitive to rhetoric and popularity. When many citizens decide quickly, the process can favor persuasive speaking and social influence. Ancient Rome developed several models over time. In the Roman Republic, a praetor could organize the legal process, but a private judge, called an iudex, might be appointed to decide a civil case, especially in the earlier and classical forms of procedure. For certain criminal matters, Romans used panels or courts with multiple decision-makers, and over time they created more permanent criminal courts. The key point is that, even when there were powerful officials, Rome often separated running the case from deciding the facts. Across history, lay judging appeared in many forms. Some medieval and early modern courts used sworn local men to present accusations or to decide facts. In some places, community members served as assessors who advised the presiding official. So, the judge was sometimes a group. Pattern 7. Professional judges and legal specialists. Over long periods, many states moved toward professional judging. Professional did not always mean modern law school training. It often meant someone whose career centered on legal work, who served the ruler, and who developed experience in procedure. In medieval royal courts, judges were often clerics or trained administrators because literacy mattered. Records, writs, and formal procedures required reading and writing. Over time, legal practice became a career path. Professional judges became especially important as law grew complex. When legal rules multiply and procedures become technical, a court needs people who know how to run it. That creates a class of legal workers, judges, clerks, advocates, and legal advisors. This professionalization could increase consistency. It could also increase distance between law and ordinary people. Pattern 8. Colonial and imperial hid courts. Large empires often created high courts staffed by appointed judges. In the Spanish world, for example, audiencias were high courts in Spain and also in Spanish America. Their judges had specific titles and roles, and the court could have both civil and criminal jurisdiction. These bodies were meant to represent royal authority and also to control abuses by local officials. In other empires, similar institutions existed: councils, supreme courts, or governal courts with appointed advisors. These courts often served two purposes at once. First, they decided cases. Second, they projected imperial control. By placing judges loyal to the crown in key cities, rulers could limit the independence of local elites. But distance remained a problem. For many ordinary people, the nearest meaningful justice was still local. What qualified someone to be a judge? Across these patterns, the qualifications for judging usually came from one or more of the following sources. 1. Status and rank. If you were a ruler, a noble, a landowner, or a recognized elder, you might be seen as fit to judge. C. Appointment by authority. Kings, emperors, governors, or religious leaders appointed judges to act in their name. 3. Learning and literacy. Religious knowledge, knowledge of legal texts, and the ability to manage written records often mattered. 4. Local trust and reputation. In community courts, a judge might be chosen because people believed he could keep peace. 5. Wealth and property. In many places, judging was linked to property ownership. The idea was that property owners had stake in stability. Each qualification shaped outcomes. Status controlled judging. The poor faced a judge from a higher class. When appointment controlled judging, the judge might serve the state's priorities. When community selection controlled judging, local bias could become stronger. HOW. Did a person's job as judge fit with investigation? Before modern law enforcement, investigation was often limited. Many systems relied on victims and families bringing accusations, community knowledge and rumor, local officials gathering basic facts, confessions, sometimes forced, oaths, ordeals, or formal reputation-based proof. This matters because judges often had different roles depending on whether the system was accusatorial or inquisitorial, using those words in a broad historical sense. In accusatorial styles, the court often waited for parties to bring the case and argue it. The judge managed rules and procedure. In more inquisitorial styles, an official actively questioned, gathered evidence, and assembled a case file. In many places, the same person did both. A magistrate might question witnesses and decide the verdict. So, the identity of the judge influenced how truth was sought. What did judicial authority look like on the ground? For many ordinary people, the judge was not a distant figure in a grand building. The judge might be a local official hearing cases in an administrative office, a Lord Steward presiding over a manorial session, a religious scholar hearing disputes near a mosque or in a court space, a rotating group of citizens in a civic court, a travelling royal justice arriving a few times a year. Some courts met on fixed schedules. Some were called only when disputes arose. Many had a public setting. Community observation helped enforce the decision because there was often no professional police to carry it out. Punishment. Power, who could sentence. In older systems, deciding guilt and choosing punishment were sometimes separate. A community might decide guilt, while an official declared the penalty. Or an official might decide guilt, but need approval from higher authority to impose severe punishment. In some empires, death sentences required confirmation. In other places, local authorities could impose harsh penalties quickly. The power to punish was a major part of what made someone a true judge. If a person could only recommend but not sentence, their authority was limited. Did systems change over time? Several forces pushed societies toward new kinds of judges. First, growing states. As kingdoms and empires expanded, rulers needed a dependable system that worked across regions. That encouraged appointed officials and standardized courts. 2. Written law and records. Once law depended on documents, literacy and training mattered more. 3. Money and commerce. Trade increased disputes about contracts, debts and property. That encouraged more regular courts and more specialized judging. 4. Conflict between local custom and central control. Rulers often tried to limit the judicial power of lords, clans, or independent cities. 5. Political legitimacy. A ruler who claimed to deliver fair justice could strengthen loyalty. Courts were not only about punishment, they were also about authority. Common limits of premodern judging. Even when older systems worked as intended, they faced limits. Limited investigation tools meant many cases depended on reputation and confession. Social rank influenced credibility. Corruption was a constant risk when officials were poorly paid or heavily pressured. Localism meant law could vary by region. Violence and private retaliation sometimes competed with court authority. At the same time, many communities developed stable methods for resolving disputes. Courts did not need modern policing to matter. They mattered because people believed decisions were binding and because authorities could use fines, confiscation, imprisonment, forced labor, exile, or physical punishment. A practical summary. Who were the judges? Across the pre-modern world, Judicial authority was commonly held by rulers and their councils, acting as highest judges. Appointed administrators, like governors and magistrates, who judged as part of governing. Religious judges, such as church officials or qadis, applying religious law in defined areas. Local elites, including lords and gentry, presiding over local courts. Elders and councils of elders, aiming to settle conflicts and restore peace. Citizen bodies, including large juries or panels, deciding cases collectively. Professional legal specialists, especially in mature court systems where procedure and records grew complex. The most important point is that judge was rarely a single universal role. It was a function tied to power, learning, and social structure. Before modern law enforcement, courts were one of the main tools by which societies tried to control violence, protect property, and define acceptable behavior. The people who served as judges were, in most places, the people who already held authority in other parts of life. That connection between judging and power is one of the clearest themes in the long history of justice before modern law.